Good morning, everybody. Hopefully, everyone can hear us. We're here in London talking to you this morning about fitness for human habitation. Are you compliant? Apologies for starting slightly later than scheduled. The building we're in is due a fire alarm, which somewhat annoyingly was scheduled for 11, but still hasn't happened. So if you hear a fire alarm, you don't need to panic. We'll just work through it, but hopefully it won't interfere with the sound quality too much. Next, please. Good morning. We're going to cover this morning an overview of both the legal aspects associated with the Act and the practical aspects, and what consequently you should be thinking about. Um, to introduce myself, my name is Mark Seaborn. I'm the Managing Director of Pennington Choices, and I'm doing this session this morning as the housing practitioner, if you like. So, originally by training an environmental health officer, cut my teeth in acting on behalf of local authorities in relation to Section 82 Environment Protection Act, and then enforcing the fitness standard in the context of private sector housing. I'm joined this morning by Giles Peaker, who's a partner at Anthony Gold Solicitors, who can just very briefly introduce himself.
Oh, good morning. I'm a solicitor specialising in housing law, and I actually played a part in the authoring the Act and seeing it through Parliament. So hopefully, I know it reasonably well.
Okay, we'll move straight on then, just with a brief overview of. Okay, so as a firm, for those of you who have not come across us before, we are a consulting and surveying business, principally based in social housing. My personal background was a director of a housing association, Riverside, and then chief executive of stock transfer in South Manchester before setting Pennington up some nearly 20 years ago now. We work with social landlords all over the country, local authorities, housing associations, and LMOs. Lots of surveying, lots of consulting. We also have a reasonable presence in sort of both healthcare and rail, principally healthcare, where we're using those sort of complex building skills, and we'll talk perhaps a little bit about that at a practical level as we work through this morning in terms of some of the things to be mindful of. I'll now hand over to Giles, who's going to talk a little bit about the legislation itself.
Okay, so just a quick overview, I suppose, of the Fitness for Human Habitation Act and how it works. What the Act actually did was to amend Landlord and Tenant Act 1985 to insert a new Section 9A, Section 9B, and a slightly amended Section 10. I should make clear all of this is for England only. It doesn't apply in Wales, certainly doesn't apply in Scotland, which is a whole separate jurisdiction. It doesn't apply to Wales. Wales is housing is a devolved issue for Wales, and they're going to be bringing in their own version under the Rented Homes Wales Act when that's finally introduced. So for England, this amendment was introduced in March 2019 with the aim to ensure that houses and flats are fit for human habitation from the start of the tenancy and throughout. From March 2019, it applied to all new tenancies, but from 20th of March 2020, it will apply to all pre-existing tenancies. So all periodic tenancies within England if they're for a term of less than 7 years. It's going to mean that any tenancies which have been in existence for 10, 15, 20 years in some cases will have this new implied term that the property will be fit for habitation in force. So it's going to be quite a big change. There could potentially be an increase in court cases. We'll have to see. My view is it will probably be a slowish start, but it may well lead to an increase because there will be a whole new range of issues for which the landlord will be responsible to the tenant, which they currently aren't. It will affect landlords, obviously. They will need to ensure that their properties are compliant, that they are fit for human habitation. It will affect tenants who, for the first time, will be able to bring claims against the landlord if their homes are not fit, as opposed to out of repair. It will affect managing agents, certainly if they have the full management responsibility for repairs, and may well affect solicitors who will either face or potentially be bringing an increase in cases related to fitness. So it's going to be really, I think, sector-wide across housing. Landlords will not be required to rectify any issue. For instance, if the problems are caused by the tenant behaving in an untenant-like way, that counts as effectively a breach of the tenancy agreement, and landlord will not be responsible for that. If the problem is caused, it's fire, flood, tempest, or effectively acts of God, then the landlord isn't responsible for the effects of that. If it's caused by the tenant's possessions, so potentially, let's say, tenant's white goods. More complicatedly, I think, but still a clear exemption is where, in order to remedy a defect, the landlord requires the consent of a third party, but hasn't been able to get it, has asked for it, but hasn't been able to get it. So that might be an adjoining property, it might be a freeholder if we're dealing with a leasehold flat, it might be planning permission if it's a local authority and they need planning permission for the specific works involved. It has to be, in effect, a residential occupier. This doesn't apply to commercial tenancies, but it's not, you don't, let's put it this way, a tenancy which then has residential subtenancies might still actually be able to claim under the Act. It doesn't cover licensees. So it only covers tenancies. So for lodgers, for example, some people housed as temporary accommodation by local authorities where it's under license rather than under a non-secure tenancy, potentially property guardians. There will obviously be the usual issues about is it a license or is it a tenancy, but if it is a license, then it's not covered by the Act. Now, once an issue has been raised by the tenant, and the kinds of things we're talking about are potentially
There's the fire alarm. Just bear with us 1 minute.
apologies, fire alarm over. That was a practice, I hasten to add. The kind of issues we're potentially talking about could be anything from excess cold, a lack of heating, a lack of ventilation, mold growth, excess heat, dangerous electrics, although we've now got separate regulations coming in for those. So there's a whole range of issues which extend well beyond the old Section 11 disrepair issues, but the principle is more or less the same on how long you've got to deal with it. When it's a problem inside the residence, inside the demised property, then once the landlord is made aware of the issue, they are on notice and they will have a reasonable time to fix it. Where the problem is to communal areas or to the fabric of the building, where it's, let's say it's a block of flats, then the landlord will be taken to be immediately on notice of the problem. So there's going to be, depending on where the problem arises from and the nature of the problem, there's going to be a range of periods to rectify it. However, if it's outside a reasonable period and there's no attempts being made to remedy the problems, there will be the potential of the tenant taking the landlord to court, county court claim for effectively breach of their tenancy agreement. And it will then be an issue for the court to decide whether there was a reasonable time involved or whether the landlord has delayed too long or failed to deal with it at all.
Okay, so I'm going to just now talk a little bit about the practical property considerations relating to applying the changed legislative provisions. So I'm sort of assuming that the majority of people who are tuning into this today have at least had a basic look at the legislative changes. And in my mind, as a as an ex-environmental health officer, if you like, it falls into two parts. You've got the top half of the list before you, which is what I would have described as the old fitness standard. And certainly when I trained as an environmental health officer in the late 80s, very early 90s, the provisions that we've now got in this new piece of legislation look virtually identical to the fitness standard that we used to have. And then you've got the very last bullet point, which is the 29 hazards associated with the housing health and safety rating system, which was introduced in 2004. Um, so what the Act is requiring at a practical level is both the presence of an issue against one of those characteristics, and as a result, a second test. It's not an automatic failure, but a second test that as a result of that issue, the home is not reasonably suitable for habitation. So, for example, if you've got some small areas of damp in a minor bedroom, at a practical level, it's unlikely that that would be enough to make that home in its entirety unsuitable for habitation. Clearly, the extent and degree of the presence of the damp, the number of rooms, the significance of the rooms, and all those type of things would be part of that judgment. But it is a second test. So fitness is the core bit of that fitness standard. Say it looks remarkably the same as the statutory minimum standard that we used to have as a country prior to HHSRS being introduced in 2004. So for those of you not familiar with it, it was a minimum statutory standard for housing applied to all housing. When I first trained, I was principally involved in enforcing that standard against private sector landlords, but the legislation applied equally to local authorities and housing associations, just that inevitably most local authorities were focused on dealing with private rented properties in that context. And there is a piece of guidance that was issued at the time. The legislation was actually the most recent edition of it when it was in law was under the Local Government Housing Act. And there was a circular, Department of Environment, so a long since precursor to the current Housing Communities Local Government Department. You can get a copy of it from the British Library. It is out of print. I have got a copy. I did get a copy from the British Library. So for those who are interested enough to want to read it, then you can get a copy from the British Library in London. So we've got those two bits of legislation, two components to the overall legislation. You've got the fitness standard, where we're looking at either defects or omissions against each of the criteria. And as a practitioner, I would look at that circular guidance, which is referenced there for you to give me some guidance as to what that would mean, how to interpret it. And then you've got the housing health and safety system as introduced in 2004. Our experience to date, interested in bringing Giles into the conversation a little bit about his experience as a lawyer, is that we've seen very little actual requests from clients to help them with claims against this. Unsurprising, I guess, is that it only applies at the moment to new tenancies. We have had conversations with a number of people, a number of clients. The North House Consortium are quite active in this space, and we've been doing some work with them. I think there is an expectation amongst some social landlords that some claims organisations are stockpiling claims. We have absolutely seen a demand from some clients in terms of HHSRS training and thinking about how they might apply that and get their staff sort of skilled up. But generally speaking, our experience has been that local forests and housing associations have not done much yet by way of sort of experience. Would that fit your sort of experience as well, Giles? What?
I think so. There seems to have been a degree of interest from some are more prepared than others, I think it's fair to say. Some don't seem to be prepared at all. I'm not expecting a massive increase in claims straight away. The main reason being that while the responsibility, if you like, the liability for fitness will kick in on the 20th of March, actual damages claims will also only run from the 20th of March. So in terms of, if you like, the sort of money component of the claims alongside the getting the works done, that's going to be relatively limited to start with because it will only run from the 20th of March. So I'm expecting a relatively slow start. That said, there are the claims farmers who I'm not a great fan of. I think preparation is going to be key. The distinction between the old Section 11 disrepair, which is effectively reactive, you waited till something broke and then you fixed it.
Mhm.
Here, because the liability is immediate, so in fact you're keeping the property fit from the start of the tenancy and then throughout, it's an ongoing responsibility. Um, that actually it needs to be more of a proactive approach, assessing your stock, considering where there have been repeat issues raised in the past, um, and obviously looking at the present condition, taking the tenant reports of, for instance, condensation and mould seriously, whereas previously the tendency has been, keep the heating on and open the window. That's not going to fly. Um, and keeping, as far as possible, a decent record of all of this. Um, one reason actually is potentially for defending claims. If you're thinking about there's a claim for condensation and mould, if you can demonstrate that before the current tenant the property had no complaints, you've got the makings of a defence that it's actually that tenant's responsibility. You need to go further, but it's still it helps. So I think there's a lot of steps that people should be taking, and I think this needs to be considered as being an ongoing responsibility. That it's not just a sort of once-off checking your stock now. It needs to be keeping an eye on it constantly.
Thank you. So as Giles sort of was sort of saying, it's just a flavour for what we think are some of the things that social landlords should be thinking about doing. Certainly a good place to start would be to look at your stock condition data and what that tells you, if anything, about HHSRS and fitness attributes. It's highly unlikely that as an organisation you will have been looking at fitness as a set of criteria in modern times, i.e. since 2004. But most people would have included HHSRS within stock condition surveys. A useful place to start, but really only if the surveying firm who have done it for have used the calculated methodology. There was a piece of guidance from CLG, I think, at the time, which sort of guided social landlords to using a sort of a presumptive approach is part of stock condition. In my view, next to useless when you also think about the sort of background and skills of most stock condition surveyors in that context. So if you've done the scored approach, that's a good place to start. But equally, there will be some data probably in your data set which will guide you about things like the presence of food prep facilities. What records have you got about what actual kit is in a kitchen or ventilation and so on. So that's obviously a good place to start. We've had a few clients who have talked about including HHSRS, particularly HHSRS, but almost a very basic fitness questionnaire in their void inspection. So clearly that's not going to cover everything, but it's a good place to start. You're in those buildings anyway, so why would you not try and pick that up as part thereof? You would want to safeguard against what I describe as own goals. The obvious ones are things like you've done a whole load of fire risk assessments recently, and I can certainly think of some local authority clients where you've made them publicly available. They're published online, type style, and you've got high risk actions in there, or indeed a high risk building as a conclusion, and you've not done the work. And I can think of plenty of organisations where that would apply. That really is an own goal. That as a potential claimant, I don't even need to visit the property in order to action that one. So avoiding sort of those sort of own goals. Inevitably, you'll want to think about your own processes in terms of disrepair protocols, and as Giles was perhaps alluding to, just making sure that they reflect the changes that are coming about. So it's not just about mending what's broke; it's about making sure that you've got the thing in the right place in the first place. You might want to think about some preemptive action against high risk properties. Examples the block of flats where you always have issues in terms of turnover complaints, disrepair claims in the past, Section 82 claims perhaps that you've perhaps had. Certainly when I worked for Riverside Housing Association many years ago, we had issues with small terraced houses in and around Merseyside, prone to dampness, prone to condensation just as a built form. So those types of buildings you might want to think about going and proactively having a look at rather than just waiting for the claim or the notice to sort of come through. And clearly to make sure that you've got access to appropriate advice where you think you need it, both legal and potentially from a surveying perspective as well. So that brings us to the end of our presentation. We've now got some time for questions. We've had a number of questions sent in. So we're going to invite the audience just to send in questions that you might have that are arising. So please feel free to do that. But in any event, while they're coming in, we can deal with them in real time. We've got some which have been already submitted to us, which we're going to just run through and talk about. So the first one is from David about how can I be assured that if I'm taken to court over an issue that is no fault of mine or my housing association, i.e. that it's tenant damage or the like, I will not be made to provide compensation or make changes. Charles, could you address that one for us?
Well, it's going to be a question of evidence. If there is no liability where the damage has in effect been caused by the tenant's own conduct, assuming that conduct is untenant-like. But to some degree, that will need to be evidenced. This is, as I said earlier, where records, for instance, about any lack of previous history of mold growth, for instance, might come in handy. Unless, to some degree, if it's contested, the tenant's going to have to establish that there is a relevant defect with the property that is causing the problems. So, you should be able to rely on that exclusion, but you may need to evidence why you are not responsible. The tenant is.
Okay. So our next one is, what if I'm unable to get the permissions needed to make certain changes from the local authority or another body?
Well, that is an exclusion. If you need consent from a third party, and planning permission would certainly fall under that. You've requested it, you've made a reasonable effort to get it, and it hasn't been forthcoming. That is an exemption, if you like, from having to carry out the works. But, it should be clear, only the works that would be covered by that planning permission. So you can't turn around and say, I'm not doing anything because we didn't get planning permission for that bit of it. But if it's covered by a third party consent and you don't get it, that is an exemption.
Are there any sort of restrictions to that third party consent? I'm thinking about sort of non-statutory bodies, Giles, where it's perhaps less formulaic or less clear as to the obligation to consider or give consent. I'm thinking from a neighbour in terms of a party wall issue, or from a
No, sure. I think it's where third party consent is required. So, for instance, if you needed access to an adjoining property or an adjoining flat, or you needed the freeholder's consent to carry out certain works to a block of individual leasehold flats, then assuming that consent is required, and that would need to be shown, but usually would be under the terms of the lease or whatever, and you can evidence it's been requested and it has not been forthcoming.
right. Is there any implied obligation on the landlord in question to enforce its rights under that context? So, for example, if you've asked the freeholder for consent, the freeholder hasn't provided, or is probably in practical terms just ignored you, but there's a not to be unreasonably withheld sort of type concept in there. Where's the limit of how hard do I have to try?
It's not going to extend to litigation.
Right.
It's reasonable endeavours.
Right. So as long as I've asked and been seen to do so,
Yeah.
probably more than once,
Followed up, but yeah.
Yeah. Okay. Where do you want to go next then? If the Act was brought in 2009, can you talk us through about why the changes are only coming into effect sort of in the very near future and what the rationale behind that was, Charles?
Yeah. So it came in 2019 for new tenancies. The rationale for, if you like, the year's delay is because this is, if you like, not entirely retrospective, but is taking effect in its pre-existing tenancy agreements. It's changing the terms of pre-existing tenancy agreements. So it would be there's a year's grace period to get the house in order before the Act applies.
Okay. At a practical level, could you just sort of say a little bit about what you would anticipate to be reasonable timeframes of the work? Clearly, I recognise it will obviously depend on the fact and degree, the nature of the building, the issues in question, but what can we learn from the existing Section 11 sort of disrepair provisions and the way in which the courts have approached that in the past to help guide landlords as to what a reasonable timeframe looks like?
I would imagine it's going to work in a very similar way to Section 11. It's going to be a question of partly the extent of the works and partly the urgency of the steps required. So, as ever it was. So you've got a flooding, leaking in the main water pipe, then it's a very short time.
Yeah.
If it's replacing the entire roof, it's potentially months. I'd expect similar fact and degree things to apply. But because unfitness almost by definition means there is a real risk to the health and safety of the occupiers, there may well be a greater degree of urgency. It's not fixing a leaking tap; it's removing an actual threat to the occupiers. So we may potentially be looking at more in the way of interim injunctions where things are truly urgent. There is a real risk. So think of it as being removing a risk within a reasonable time. If you can mitigate the risk and then do more substantial work later, that's probably a sensible approach.
Okay. Would it be? Can you say something a little bit about the degree to which you would expect either? So a couple of things that might apply to practitioners in this context. Either budgetary constraints. I'm sort of assuming that's really not an issue.
Yeah, it's not an issue.
But the other one that also appeared to mind was perhaps particularly for complicated buildings, and I'm thinking about fire safety works where you've got an obligation under public procurement regs in terms of procurement. How would that play out in terms of sort of setting the time frame if a social landlord was saying, look, I need 6 months to procure, for example, before I can do the work?
Well, I would be genuinely astonished if a court wouldn't be taking something like that into account in terms of assessing a reasonable period. Now, a landlord can't be asked to do something which is in effect impossible or would put them in breach of their own statutory requirements. The financial restraint conditions, no.
Okay, and we've had a couple of other questions come in. One from Samantha about the impact of pest infestation in this context. So, pest per se wouldn't be an issue, I wouldn't have suggested.
It is.
Okay, go on, tell us.
It's one of the HHSOS categories.
Right. Okay.
So yes, and actually, currently pest infestation can really only be dealt with in one of two ways. One is a common law nuisance claim where the pests have come from property that's under the landlord's control. So usually in a block of flats and it's coming through the ventilation pipes or the common areas. Or the other one is a Section 82 private prosecution under the Environmental Protection Act.
Yes, which is one I've dealt with more commonly personally.
Yeah. But here, if there is pest infestation and it is of a nature, again, is it a
to
risk?
Give a Cat 1 or a Cat 2 hazard, yeah?
Yeah, well, yeah. I mean, I don't want to tie it too closely to the HHSRS. It's just, does it fall under one of the HHSRS categories?
Yep.
But yes, it has to present a risk to the health and safety of the occupiers. So if you have got a health risk arising from pest infestation, I think it would fall under fitness.
Yes, and how would that interact with the causes of an infestation? So infestations are often associated with building defect, if that makes sense, and certainly in a housing context.
It's kind of free of those limitations. So if you had under Section 11, if you're also claiming for a consequential pest infestation, it's because they were coming in because of the disrepair.
Because of the hole in the whatever, yeah.
Or if it was the common law nuisance claim, they were coming in from the landlord's own property. So that's where the nuisance was coming from. Neither of those are at issue here. So in fitness, is there a pest infestation? Is it presenting a risk?
Yes, and the only exception to that presumably would be a debate about is this a defect in the building, which might be about the extent of an infestation, i.e. is it affecting other dwellings nearby, i.e. the block of flats or the neighbouring houses, or is it localised, and those types of discussions.
Yeah, it's going to be a question of remedy rather than liability. I mean, the only liability issue is going to be, is it effectively caused by untenant-like conduct?
Yes. Yes, and presumably the onus would be on the landlord to demonstrate that rather than the other way around. Yeah. Okay, that's really helpful, thank you. Another question we've had in is about the low SAP as an issue. Low SAP standard assessment procedures is energy inefficient dwellings is not part of either fitness standard or HHS directly, but excess cold is. So at a practical level, a dwelling with a very low SAP rating would be de facto evidence of a building which is likely to be subject to excess cold. And also there is guidance issued with as part of the HHSRS pack as to how a practitioner would assess that. Effectively, the answer cannot be just turn up the heating. So SAP effectively assesses both the performance of the building and also the likely performance of the energy of the heating system that's installed, a gas central heating system, or indeed electric space heaters, i.e. plug-in heaters, and it makes some standard assumptions. So to give a low outcome, if it's got a low SAP score, it's highly likely, I would suggest, that an expert and indeed a court would hold that it was subject to excess cold. And another point from Chris, the same questioner also asked a little bit about whether we could just elaborate a little about why we think claims won't flood in straight away, which is probably more of a Giles question than a me question.
Well, I think there's a number of reasons. One is simply going to be capacity. That most of the people who do these kind of cases are already doing a lot of these kind of cases. Remember that fitness claims will actually, I think, most of the time effectively supplant existing disrepair claims. So they're sort of one-for-one replacement. But I think there is also the point that the damages for breach of fitness are only going to start from the 20th of March, so they're not going to be substantial for at least the first few months, to a year. So I would expect things to ramp up, but relatively slowly. You may well find yourself unfortunately facing bad claims from certain claims farmers. I'm a claimant solicitor, but my advice in dealing with bad claims is don't be afraid to fight them. The claims farmers' business model is usually based on people giving in and paying them off at an early stage.
Yes. And presumably that economic behaviour it gets more compelling the longer the claim is running after the 20th of March.
Yes, certainly in terms of the tenant damages.
And
so claims farmers take an excessive cut of those, but So I think there may well be a lot of people chancing it at an early stage. I think the advice would simply be make a proper assessment of the claim. If it's not a good one, fight it. If it's a good one, do something about it immediately.
Okay. Okay. I don't think we've got any other questions, so I think we'll probably call it a day there. Thank you everybody for tuning in. Hope you found it vaguely useful, and if I can thank guest Giles in particular for adding his quite unique expertise and perspective, having co-authored the Act in the first place. I know you can't contribute in that context, but I'll say thank you on behalf of the audience for his time and expertise. So thank you for tuning in.